Breaking news coming out of Washington tonight, and this is the one legal experts have been warning about for years. Moments ago, the Supreme Court issued a stunning 6-3 emergency ruling that fundamentally alters the power map of the United States. We are receiving the text of the order now. There was no oral argument. There was no full briefing. This came down through what is known as the shadow docket, and the impact is immediate. In a split decision along ideological lines, the conservative supermajority has just effectively dismantled the nationwide injunction. If you are wondering what that means, it means the stop button is gone. For decades, if a federal judge in Texas or California thought a new federal law was unconstitutional, they could hit pause for the entire country. As of 6 p.m. Eastern tonight, that power appears to be history. This is not just a legal technicality. This is a seismic shift in how the United States government functions. It means that starting tomorrow morning, a federal law regarding immigration, healthcare, or gun control could be fully enforced in one state while remaining illegal in the state right next door. The Dissent, written by Justice Kagan, calls this a descent into, quote, administrative chaos and a fragmented union. To understand why tonight's ruling is shaking the foundation of American governance, we have to look away from the headlines and look at the machinery of the court itself. Most Americans believe the Supreme Court works like this. A case is argued, months pass, and then, in June, we get a decision. But that is the merits docket. What happened tonight took place in the shadows, on the emergency docket. It is fast, it is often unexplained, and increasingly, it is where the real law of the land is being written. Here is the context you need. For the last 20 years, both Republican and Democratic administrations have faced a common enemy, the Universal Injunction. When President Obama tried to change immigration rules, a single judge in Texas stopped him nationwide. When President Trump tried to restrict travel, a single judge in Hawaii stopped him nationwide. It became a game of judge shopping. Activists would find one sympathetic courtroom, file a lawsuit, and block a federal policy for 330 million people. Tonight, in a case involving the new federal regulatory standards, the Supreme Court didn't just rule on the specific law, they ruled on the mechanism. The 6-3 majority opinion, unsigned but clearly carrying the voice of the conservative bloc, stated that a single district judge does not have the constitutional authority to dictate policy for the entire nation. So, what happened? The court has stayed the lower court's order. The immediate question is, what does this look like on the ground tomorrow? We spoke to legal analysts 10 minutes ago who are calling this the Balkanization of American law. Imagine driving across state lines. In Ohio, a specific federal environmental regulation is in full effect. Factories are shutting down or retrofitting. You cross the border into Kentucky, which is part of a different federal circuit that has a stay in place, and those same factories are operating business as usual. This destroys the concept of a uniform rule of law. And the scary part? This applies to everything. Let's talk about the human impact. This isn't abstract. Consider the pharmaceutical industry. If a judge in Amarillo, Texas, rules that a certain FDA-approved medication is unsafe under the old rules, that drug was pulled from shelves in New York, Seattle, and Miami. Tonight's ruling suggests that moving forward, the drug might only be banned in the Northern District of Texas, or perhaps the Fifth Circuit. This creates a nightmare for compliance. A national pharmacy chain now has to navigate a patchwork of federal legality. Can they ship to this zip code? Is the driver liable if they cross a state line? Or take immigration? We're looking at a scenario where federal deportation priorities could be aggressive in Arizona, but blocked in California. Not because of state law, but because of conflicting federal court rulings that the Supreme Court is no longer pausing nationwide. The 6-3 split is telling. This wasn't a soft ruling. The dissent from Justice Sotomayor, joined by Justices Kagan and Jackson, is scathing. In the dissenting opinion, Justice Sotomayor writes, "The court today invites a chaotic patchwork of federal authority that the Constitution was designed to prevent. By eliminating the nationwide injunction, the majority ensures that rights will now depend on geography, not the law." She is arguing that the Supreme Court is abdicating its role as the final arbiter of consistency. By refusing to let a lower court pause a law for everyone, they are letting the law fracture, but the majority sees it differently. Justice Gorsuch has long argued that universal injunctions are a modern invention, a power grab by lower courts. To the conservative majority, tonight is a restoration of order. Their argument is, why should one judge appointed by one president in one district have the power to veto the elected president of the United States for the whole country? It is a clash of two philosophies, where one values consistency and stability, the old way, the other values executive power and limiting judicial overreach, the new way. And the winner tonight is the executive branch, but at the cost of national unity. The consequences of this are already rippling through Washington. We know that the Department of Justice is currently drafting guidance memos for every federal agency. The question on everyone's mind, is this retroactive? Will previously blocked laws suddenly spring back to life in states that weren't part of the original lawsuits? Legal scholars say, yes. Think about that. Laws that you thought were dead, blocked by a judge 3 years ago, could theoretically reactivate tomorrow morning in 40 out of 50 states. The zombie laws are waking up. We have to ask, why now? This ruling didn't happen in a vacuum. It is the culmination of a systematic effort to reshape the judiciary. For years, we watched the nomination battles. We watched the filibuster end. We watched the court expand its use of the shadow docket. But tonight is the payoff of that strategy. The court is saying loud and clear that the era of the activist district judge is over. But in doing so, they may have ushered in the era of the fragmented citizen. If you are a business owner operating in multiple states, you need to call your lawyer. If you are an activist relying on the courts to stop a federal policy, your strategy just evaporated. You can no longer win once and save everyone. You now have to fight everywhere, all at once. There is a phrase in legal circles, the law of the circuit. It used to mean a technicality. Now it defines your reality. The 6-3 emergency ruling has stripped away the safety net of uniformity. We are entering a period where the United States might function less like a single nation and more like a collection of legal fiefdoms, bound by a federal government that has different powers depending on which side of a river you are standing on. As we sign off tonight, the text of this order is being analyzed by thousands of lawyers, but the message is simple and undeniable. The Supreme Court has spoken. The national pause is dead. Oh, and for millions of Americans, the legal ground beneath their feet just shifted. We will continue to track the fallout of this decision hour by hour. This story is not over. In fact, the confusion is just beginning. For now, reporting from Washington,